Chapter 3. Rape. Article 266A. Rape. When and how committed. Note: under RA 8353, the Anti-Rape Law PF 1997, there are two modes of committing rape. 1. Article 266A, paragraph 1 refers to rape through sexual intercourse, otherwise known as organ rape or penile rape, of which the central element is carnal knowledge, which must be proven beyond reasonable doubt. 2. Article 266A, paragraph 2, rape by sexual assault, otherwise known as instrument or object rape, or gender-free rape. It must be attended by any of the circumstances enumerated in subparagraphs AD of paragraph 1. Note: in the first mode, offender is always a man, while in the second, offender may be a man or a woman. Note: offended party is always a woman in the first mode. In the second mode, it may be a man or a woman. Note: rape is committed through penile penetration in the first mode, while the second is committed through inserting the penis into another's mouth or anal orifice, or any other instrument. Note: penalty for rape under first mode is higher than that of the second. Note: a woman can be a principal by direct participation in rape under the first mode. Elements of rape under paragraph 1. 1. Offender is a man. 2. Offender had carnal knowledge of a woman. 3. Such act is accomplished under any of the following circumstances: A. By using force or intimidation, or B. When the woman is deprived of reason or otherwise unconscious, or C. By means of fraudulent machination or grave abuse of authority, or D. When the woman is under 12 years of age or demented. Note: penetration, even partial, is necessary. Proof of omission is not necessary. Note: if there is no sexual intercourse and only acts of lewdness are performed, the crime of rape through sexual assault under paragraph 2 are acts of lasciviousness only. Note: a broken hymen is not an essential element of rape. Exact date of sexual assault is not an essential element of rape. Note: only one of the four circumstances mentioned in paragraph 1 is sufficient. Elements of rape under paragraph 2. 1. Offender commits an act of sexual assault. 2. The act of sexual assault is committed by any of the following means: A. Inserting his penis into another person's mouth or anal orifice, or B. Inserting any instrument or object into the genital or anal orifice of another person. 3. The act of sexual assault is accomplished under any of the following circumstances: A. Using force or intimidation, B. When the woman is deprived of reason or otherwise unconscious, or C. By means of fraudulent machination or grave abuse of authority, or D. When the woman is under 12 years of age or demented. Note: a violation of the body orifices by the fingers is within the expanded definition of rape under RA number 8353. Note: degree of force necessary to constitute rape and rape by using force and intimidation need not be so great or of such character as could not be resisted. Note: any physical overt act manifesting resistance against the rape in any degree from the victim is admissible as evidence of lack of consent. Note: resistance when futile does not amount to consent. Note: silence may amount to tacit consent. Note: circumstantial evidence may prove rape. Note: moral ascendancy or influence exercised by the accused over the victim substitutes for the element of physical force or intimidation. Applies to rape committed by A. fathers against their daughters, B. stepfathers against their stepdaughters, C. a godfather against his goddaughter, D. uncles against their nieces, E. the first cousin of the victim's mother. Note: no proof of force or intimidation necessary if offended party is deprived of reason. Note: there is rape because the woman is unconscious, in the following cases: A carnal act while offended party was asleep. B. When woman is in a lethargy produced by sickness. C. When the woman was raped while unconscious and extremely intoxicated. D. When narcotic was administered to the woman, but if consent is induced by the administration of drugs or liquor, which incites her passions but does not deprive her of her willpower, the accused is not guilty of rape. E. When a potion is given to the woman. Note: consummated rape, not essential that there be a complete penetration of the female organ. The slightest penetration of the labia consummates the crime of rape. The absence of spermatozoa does not disprove the consummation of rape. Note: frustrated rape. There is no crime of frustrated rape. Exception: People v. Aranea. Note: intent to lie with a woman distinguishes attempted rape from acts of lasciviousness. Attempted rape is committed when the direct overt acts of the offender establish the intent to lie with the female. Guidelines in appreciating the age of the victim in rape cases. 1. Original or certified true copy of birth certificate equals. 2. In the absence of a birth certificate, similar authentic documents showing victim's age. 3. Credible testimony of the mother or any relative by consanguinity or affinity, if the above is not available. 4. Testimony of victim of all foregoing cannot be obtained. Note: character of the offended woman is immaterial in rape. Article 266b. Penalties. Penalties for rape under paragraph 1. 1. Rape committed under any of the four circumstances, reclusion perpetua. 2. Rape committed with the use of a deadly weapon or by two or more persons, reclusion perpetua to death. 3. Rape where victim becomes insane, reclusion perpetua to death. 4. Attempted rape and homicide is committed, reclusion perpetua to death. 5. Rape with homicide, death. 6. Rape with aggravating or qualifying circumstances, death. Penalties for rape under paragraph 2. 1. Rape committed under any of the four circumstances, prison mare. 2. Rape committed with the use of a deadly weapon or by two or more persons, prison mare to reclusion temporal. 3. Rape where victim becomes insane, reclusion temporal. 4. Attempted rape and homicide is committed, reclusion temporal to reclusion perpetua. 5. Rape with homicide, reclusion perpetua. 6. Rape with aggravating or qualifying circumstances, reclusion temporal. Indemnity and damages in rape. 1. Civil indemnity, mandatory upon the finding that rape took place. 2. Moral damages, automatically granted in rape cases without need of further proof other than the commission of the crime because it is assumed that a rape victim has actually suffered moral injuries entitling her to such award. 3. Exemplary damages may be awarded in criminal cases as part of the civil liability if the crime was committed with one or more aggravating circumstances. Note: the penalty of reclusion perpetua without eligibility of parole shall be imposed for rape in the following cases. 1. On occasion of the rape, a homicide is committed. 2. Victim is under 18 years of age and offender is a parent, ascendant, step-parent, guardian, relative by consanguinity or affinity within the third civil degree, or the common law spouse of the parent of the victim. 3. Victim is under the custody of the police or military authorities or any law enforcement or penal institution. 4. Rape is committed in full view of the husband, parent, any children or other relatives within the third civil degree of consanguinity. 5. Victim is a religious engaged in legitimate religious vocation or calling and is personally known to be such by the offender, before or at the time of the commission of the crime. 6. Victim is a child below 7 years old. 7. Offender knows he has HIV/AIDS or any other sexually transmissible disease and the virus or disease is transmitted to the victim. 8. committed by any of the armed force of the Philippines or paramilitary units, or the Philippine National Police or any law enforcement agency or penal institution. When the offender took advantage of his position to facilitate the commission of the crime. 9. Victim has suffered permanent physical mutilation or disability. 10. Offender knew of the pregnancy of the offended party at the time of the commission of the crime. 11. Offender knew of the mental disability, emotional disorder and/or physical handicap of the offended party at the time of the commission of the crime. Note: pursuant to RA number 9346 prohibiting the imposition of the death penalty, the penalty of reclusion perpetual without eligibility for parole shall be imposed, in lieu of death. Note: rape with homicide is a special complex crime. Note: where homicide is committed by reason or on the occasion of the rape, there is rape with homicide even if the deceased is not the victim of rape. Article 254. Discharge of firearms. Elements. 1. Offender discharges a firearm against or at another person. 2. Offender has no intention to kill that person. Note: act of constituting the offense is shooting at another with any firearm, without intent to kill him. If the firearm is not discharged at a person, there is no crime of discharge of firearm. Note: firing a gun against the house of the offended party at random, not knowing in what part of the house the people inside were, is only alarm under Article 155. Note: complex crime of illegal discharge of firearm with serious or less serious physical injuries if the offended party is hit and wounded. Note: no complex crime of only slight physical injuries are inflicted. Note: crime is discharge of firearm even if the gun was not pointed at the offended party when it fired, as long as it was initially aimed by the accused at or against the offended party. Article 247. Death or physical injuries inflicted under exceptional circumstances. Requisites for the application of Article 247. 1. A legally married person or a parent surprises his spouse or his daughter, the latter under 18 years of age and living with him, in the act of committing sexual intercourse with another person. 2. He or she kills any or both of them or inflicts upon any or both of them any serious physical injury in the act or immediately thereafter. 3. He has not promoted or facilitated the prostitution of his wife or his daughter, or that he or she has not consented to the infidelity of the other spouse. Note: Article 247 does not define and penalize a felony. Note: the word surprise means to come upon suddenly and unexpectedly. Note: the killing of his spouse by the accused must be by reason of having surprised her in the act of sexual intercourse with another person. Note: Article 247 is not applicable when the accused did not see his spouse in the act of sexual intercourse with another person. But it is enough that the circumstances show reasonably that the carnal act is being committed or has just been committed. Note: the killing or inflicting of serious physical injuries must be 1. In the act of sexual intercourse, or 2. Immediately thereafter. Note: the killing must be a direct byproduct of the accused rage. Note: where a third person suffers physical injuries as a result of being caught in the crossfire, one committing the offense is liable for all the consequences of his act. The rule presupposes that the act done amounts to a felony. Note: not applicable to a person who consented to the infidelity of spouse, or who facilitated the prostitution of his wife or daughter. Note: parricide committed under Article 247 is not punishable with reclusion perpetua to death.